I'm thrilled to have you. We have existed, kind of cohabitated in New York City for more than a decade now. How long have you been in practice, out of curiosity?
Yeah, Vince, by the way, thanks for having me on the show. So believe it or not, I've been practicing law about 23 years now,
Wow.
and I started my practice in April 2001. So it's been a while. It doesn't seem that long, but it's been quite some time.
Wow. You know, I got to tell you, I thought
Uh-huh.
you seem like a very young man, and you are a young man, but I did not know 23 years. That's incredible.
Well, thank you, Vince. I really appreciate that. I like where this is starting already. This is a fantastic conversation.
I would have
It's
thought,
getting.
late 30s, really. You got to tell
Oh,
me the
thank
secret off air. Um,
thank you very much. I think the
so
beard is
now
starting
you
to give it away a
do
bit, but
you do both kind of employment compliance work, but also employment defense work. Is that both the day-to-day helping of businesses and advising businesses, but also the litigation end? Is that correct?
yes, that's
Okay.
absolutely right, Vince.
And I love that because it's a rare perspective, because many attorneys choose one or the other, right?
Right.
And it leads to kind of a breaking up of the skill sets, and often I would think incomplete answers, because the compliance attorney who sets everything up,
Mm.
when things go wrong, basically they just say, yeah, I told you not to do that.
Right.
Go hire this guy, right? And you don't do that. You would say, okay, well, listen, we did everything we can to avoid this, but now
Right.
we have a small problem, and let's work on it. Let's fix it together, right? Is that accurate?
I'd say so. Yeah, I've coughed with that with a little bit of humor. Sometimes I did everything I could to help them avoid it. Sometimes, like the clients don't always follow the steps in place, but a lot of times they do. And I try to look at it, Vince, like, if is the client coming from a place of where they maybe dropped the ball? Do they recognize it and want to try to correct things going forward, or are they very hostile and defensive? And I think that the latter, the former approach, it often is better for everyone, right? In terms of not only solving the problem at hand, but also hopefully staving off future problems of discrimination or a lawsuit. So I think it's a good point you raise about a holistic approach. If you can have compliance and defense married together, it's a good way to approach your clients and their needs.
Yeah,
Yeah.
I agree. And I think what you're offering is a higher value proposition than some firm that just comes in looking to bill $1,600 an hour once there's a problem, right? It's just
Right.
not going to be the same level of representation. They're not going to know the players. They're not going to have the depth of knowledge about the business. It's not going to be equal to what you're offering, in my opinion.
Sure.
But I guess I say that as a plaintiff's attorney. So I just think people coming from your combined skill set will do a better job in general. So I think brings us to our first topic. When
Sure.
someone brings you, a potential client or a client, an existing client maybe, brings you a case, a workplace discrimination case or a workplace sexual harassment case, what is generally the first thing you think? How would you address that?
Yeah, it's a great question, Vince. Well, the first thing I think about when they say a client comes to me with a case or a matter is I think about getting to know what happened and getting the big picture, which kind of comes back to what we were just saying. I want to take a look at what happened, say, I think when the client came to me. Usually the client comes to me with a specific instance that brings them to my door or to my phone, right? They're a single employee alleging discrimination, whether it's harassment or failed to get due promotions, or maybe it's a wage and hour claim or violation. But I want to see what are the facts around that situation. But I also want to look at say what is the bigger picture that the client has going on there. So I think about my client, potential client. First, I also think, is this client, how truthful are they, and how much are they in the know of what's going on? And so I try to look for cues of that in our conversation, inconsistencies, what are they leaving out? I also take into account, when are they coming to me, right? Are they coming to me right off the bat because employers are complaining about discrimination, right, Vince? Or are they coming to me after a demand letter? A lot of times they come to me after someone like yourself, like this skilled, seasoned plaintiff's attorney, writes a good, solid demand letter, and it brings it to their attention that this is a problem. But if an employer comes to me when the complaint's filed in court and the answer is due in a week, to me, it's like that's insight into what else might be going on with that employer? Is this how they handle situations? Do they sweep things under the rug? Do they ignore problems? Because then when they tell me that they were really on top of everything that's happening, I have to have a little bit of skepticism about that and investigate.
Yeah, that makes a lot of sense. So as a plaintiff's attorney, I often notice a huge difference between a Fortune 500 company and how they might react to something versus, a mom and pop, or even a closely held family corporation that does 5 million, 10 million a year. The
Sure.
spectrum is so different. The Fortune 500, I often see as just pure cost benefit, right?
Right.
They don't care. No one cares. And it's not really their money. And also many of those people probably want to do the right thing, A smaller corporation, a family corporation, something, maybe the allegation is Uncle Stevie used a racial slur in the workplace. And nobody from the family saw it. There's a couple witnesses that it happened, mind you, but nobody from the family saw it. And everybody says, no, Uncle Stevie wouldn't do that. And you get, it's just a different response than a corporation saying, well, there's a decent chance this happened. 3 people said it happened. And we should probably deal with this liability. It's just a very different. Do you find anything like that?
I do, Vince. It's a great question. I think about, pardon me, what's the size of the client coming to me? Now, I'll be honest, I don't get Fortune 100 companies as a solo, solo attorney. I have a couple of associates that work with me and a paralegal, but I'm not a big giant defense firm, so I don't get many Fortune 100 per se, but I do get some clients different sizes. And I find that often a company with a larger, just less at stake, the family mom and pop businesses also have that very much, it's personal for them, right? They often feel, hey, I'm being accused of something I didn't do. And they often say to me off the bat, I want you to know I'm not a racist, I don't see color. And it's that kind of, so I have to say, like a lot of people I think generally believe that about themselves, but the challenge is you have to see, are you yourself perhaps maybe blind to certain types of implicit bias or discrimination in the workplace, right? Because it's not just about the person that used a racial slur, it's how did you as a company react? Did you tell the person, okay, we dealt with it, now let's get over it, time to move on? Did you have informed the employee about what their rights are to go forward? Did you properly discipline the person who may have, made those comments? So, but to answer your question about how it's dealt with, like, I do think that bigger companies often it's a cost benefit analysis, right? If they can claim this, like, how much would it cost us as a company to defend this case, right? Might others come forward if they get wind to this? And do we want to just settle quickly and for less money? But yes, smaller companies often there's a combination of the own personal feelings of betrayed by the employee. And mind you, I think the employee often feels the same way. I gave my blood, sweat, and tears to this company. I worked hard, and they just let someone sexually harass me, and this is not right. So it's really about, in that situation, what I find, Vince, is like, let's get down to the facts and the evidence, and let's find out what happened from the employer. Let's do an investigation. Let's gather documents, talk to witnesses. And what I often find is that, so since I did mention how long I've been practicing, I remember TV shows from the 80s where, they have a comedy of what happened, and they would show one person's perspective, and then they blur the screen a little bit and show the other person's accounting of what happened. It was very polar opposite. In each one, the person telling the story is the good guy or good gal, and the other one's the villain, right? So I try to take those sort of that mindset out of the equation. Usually what happens somewhere in the middle, that someone maybe did drop the ball at the company and didn't properly investigate. But often, other times, the employee might be misinterpreting the situation as discriminatory. And there are cases of disgruntled employees who bring, frivolous claims. There are cases of employees that bring valid claims, but maybe their sense of damages is out of whack. They want, like $2 million, and they were the co-check person who was, making minimum wage and got a new job a month later. So that's, I hope that's a sort of a long answer to your question, but short answer is, there are different approaches that you take with different size companies.
I appreciate that. Now, you did mention kind of that some people's unreasonable expectations. This is something we deal with on our side all the time. And
Sure.
I always think it comes from the fact that only the biggest verdicts ever get printed, right? If you, I'll use an example from my own life. A partner of mine, many years ago, won a pair of nurses over $15 million, right? And that was a tremendous win. And of course, it got press all over the place. Of course, they only collected $700K, right? I mean, and it wasn't for want of trying, but it was just because the judge said, hey, jury, that's not how we calculate damages, and adjusted it down, right? And nobody ever saw that, right? So it's one of those things where, like, I understand how people have these inflated perceptions of numbers because they only hear 15 million, 30 million, 200, but they in their own claims want to make those demands. And often the way that you and I know damages are calculated, we can't really substantiate those demands. If somebody lobs in a demand to you and you just, there's no way you can calculate that to substantiate it. What do you think that does? In terms of the negotiation, in terms of the back and forth and communication, do you think it hurts the plaintiff? Do you think it helps them? I would love to hear your thoughts on this.
Sure, I mean, absolutely. Absolutely. Let me get some water, pardon me, a little bit of a dryness in the air today, but no, I think it's a really good point you're making, Vince, really. And what I find is, like, you're right, well, first I'll say about people watching the news or hearing about larger verdicts, that I remember being a plaintiff's lawyer a long time back, and I do know that frustration you're talking about. Sometimes, like, defendants also read about either a case being dropped, or they compare themselves to that company. They say, hey, I'm not Google, I'm not Uber or Lyft, I'm a small company, so my damage should be very small in comparison. So believe it or not, it can actually hurt when we as defense lawyers evaluate the claim. But to answer your question about, like, what do I think, well, what's my reaction when a plaintiff's attorney, I'll take it, or maybe if they're not represented, they're pro bono, a plaintiff himself comes to the super inflated damages. My first thought is, like, sort of, where's the aspirin? Because I think I'm gonna have a headache here. I'm gonna be dealing with maybe, like, someone that's not, say, is realistic about, what the case is worth. It becomes harder to settle the matter. I think that the plaintiff's attorney in that case might not be so experienced. I'd have to wonder. So, for example, I had a case a couple of years back, and first time with this plaintiff's attorney, never quite met them before. I'm not going to mention names. It's a small, small industry, but I was looking at the damage, what it might be, and I could see some liability issues for sure. And I was expecting a certain demand, and maybe $100K, just kind of, and I knew we'd go down from there. And they came out with $1 million. And I looked at this like every way, 6 sides of Sunday, whatever the expression is. I couldn't imagine, in a best case scenario of everything under the sun, like a home run, I couldn't imagine even getting to like 500,000, even 400,000 in a court. So that sort of had the sinking feeling, maybe not sinking, but sinking from my client, because my client really wanted to resolve the matter. They said, hey, we did drop the ball here. I think we made a mistake. We didn't pay the proper wages and overtime. And there's proof of that. And we want to do the right thing. We were told that, like, if you pay off the books and you are paying cash, that's okay. I'm not sure who told them that, and it's not an excuse. As we all know, ignorance is no excuse for the law. People watching today, any one of you who's been driving, pulled over by a police officer, maybe upstate or somewhere driving, you can't say, I didn't know the speed limit changed. So same thing with the employers. You can't just say I didn't know about, that paying cash is not. But I would say, like, hearing about, so if you have clients who are telling you, hey, Vince, we should ask for $1 million and they'll come down from there, it actually hurts your case, because I'm much less likely to take you seriously and take what you say seriously. And maybe even, you may come back then have to really cut your demand into like a third of that. And now I'm starting to wonder, do you know what your case is worth? So that's my thought on that, Does that make sense, kind of, from your perspective?
Certainly it makes sense to me. I mean, it's always one of these things where you're trying to educate, trying to share how these things are calculated, and, kind of dealing some basic concepts like, hey, if we're being honest, we'll never win this much at trial.
Yeah.
So why would the other side be responsive when we make a demand we could never win? It's that's far worse than the worst case scenario.
Mm-hmm.
If they embrace trial and all the risk of trial, in which they may win, right? It
Right.
just doesn't make sense. And
Yeah.
what you said, that it leads you to believe the plaintiff's attorney is not perhaps as seasoned, right?
Right.
That's an issue. And you'll
Mm-hmm.
get situations where you're trying to explain to the client, like, listen, they're just not going to take us seriously. This is not
Right.
a wise demand. And it's the bane of my existence. If I'm being honest, you know, people say, you know, they're almost like trying to talk you up, like, listen, you're great at your job. You're going to go and get me 30 million. And it's like,
right.
I appreciate the confidence, but I assure you, it's not going to happen.
Right. You're good at your job, but there are
Right.
other factors beyond just being good at your job, I think, that dictate how much you can get in a case. Things of issues of, like you mentioned, right, front pay or back pay, or like emotional stress damages. What's the publicity aspect? So, but no, I hear you about that. And you know, Vince, I'll share a little bit with you, because as I think you and I have pointed out in prior discussions, like, you know, we're not enemies, and nor are, I think, our clients enemies. I think about it really. I think that you know, we're just like on opposite sides, doing the best we can with mutual respect for each other is what we do. And I would say that, like, my equivalent of that maybe is the client that says the client that doesn't understand how these negotiations work, that says, like, you know what, like don't even offer like a dime, don't even mention the word settlement, don't even bring it up in a conversation. And I'll explain to them, okay, well, I think we should, like, often I'll do an investigation, I'll get certain documents, I'll speak to witnesses, I'll look at the pros and cons of the case, the weaknesses, the liabilities, and also look at the costs. As you mentioned earlier, a very good point you made, even if the case looks pretty strong, sometimes damages are quite low. And so will you pay me more in attorney's fees to represent you in this case, and maybe go to trial, you might be paying 3 times what they're worth. So why not just settle this now? But what I find the bane of my existence is the client that says, don't even mention something, like, don't even bring it up. If they come to you, give them a 0 response. Because all it's going to do is drive this towards, okay, I guess we're litigating. So I would rather say to someone in your shoes, hey, so what are you looking for? Like what's your client's, what's your demand? What are you looking? Let's just talk honestly. We're going to eventually get to a case, and if we get to federal court, often the court will want us to mediate. Often, you and I know it takes a long time to get there, and our clients' money, time, and effort, and stress. So what are you looking at here? Like, what do you think this case is worth? And something along those lines. And I find most plaintiffs' attorneys find that refreshing. They want that kind of response, as opposed to, my getting all puffed up in a fake, like, you're never going to see a dime in this case, And I remember, hearing that years ago and saying, okay, maybe you're wrong about that. So.
Yeah. I certainly, I can think off the top of my head of a few defense attorneys who who take that "you'll never see a dime" stance. It's like, sir,
right,
sir, we've been doing this for 10 years now.
Right.
How many times have you said that?
Right.
Of those times, how many times did you pay? Like, it's it's just a little bit silly at that point. I couldn't agree more.
Good point.
I really couldn't. Yeah. Well, okay, so that mutual respect, that kind of getting to a realistic result, leads me to my final question for today.
Sure.
We're here in New York. The Southern District of New York has that mandatory mediation policy. We're surrounded by some amazing mediators, Deborah Reich over at the EEOC, Marty Schein. Like, New York City, I have always thought of as kind of the forefront of mediation for our field, in a way.
Yes, I agree.
Mediation. Is it worth it? Is it a good use of time? I just love to hear your thoughts.
Yeah, sure, Vince, sure thing. And again, I really appreciate your perspective from the plaintiff's side on this as well. It's been a while since I've been the plaintiff's counsel in cases, but I will say that mediation, like, I'm actually overall a big fan of it. So my perspective on mediation is that, like, as a whole, I think it's worth the time and investment, especially if you can say, like, maybe even uncover some blocks between the parties that are maybe keeping them from reaching a reasonable settlement. Maybe one that, say, compensates the plaintiff justly for what they've suffered, without, say, an overinflated sense of, okay, here's $20 million, or something that, like, say, makes the defendant kind of aware that they did actually have some role in this, and they can't sort of just, say, self-justify or deny by making excuses. I think mediation can be great because often what happens is like each side gets so entrenched in their own viewpoint. And if you as the employer point out the weaknesses too often, the client can get resentful towards you. And if the other side points it out, your client just says that's just what they're paid to do. So a mediator kind of comes in saying, look, like from the start, I'm going to wear a neutral hat and to point out like, your strengths and weaknesses to you. That being said, I think not every case is meant for mediation, unless of course the court, as you pointed out correctly, may require it. Sometimes, like if you get the sense that the other side just tells you straight up that they're not going to negotiate, they only want to see a trial or a 7-figure number, and it's rare, but it does happen, that you might find yourself, it might not be worth the time if you don't have to mediate. But most of the time, overall, I really think it's worth it because, again, trial becomes so expensive. It's such a wild card. If you can get to a certain resolution, and then maybe even help for, I try to say to my client, look, if you spend this much money and resolve this sooner without the wild card risk of litigation, the publicity of a trial, maybe you can take the money you've saved, my attorney's fees, and maybe bring me back to help you, like, how do we avoid this going forward? What do we do to correct what's happening in the workplace?
Yeah, I agree. That would be a great approach. And I think more and more companies are seeing that as the path forward, right? There's no more of this, we're just going to get hit once in a while.
Right.
No. Now there's this realization, we could do better. And that would both be great in terms of us being better human beings, but also great in terms of our bottom line, right? And people like you can advise on how to go about that. And I think it's so important. You kind of mentioned my perspective on mediation. It's, for me, it all comes down to the mediator. It really does. You're going to have mediators who are just going to, I'll start off saying, I don't really like exposing my client to the defendant. I think it is, it's a bit detrimental. Emotions can ride really high in a mediation. And most of our clients, yours and mine, are not people who selected an industry where you have conflict every day as their career. Right? We said, you know what I want every day? I want to fight with people about hate crimes, right? Like that.
We did, right?
And, and most people, thank goodness, say, hey, that sounds kind of hard. I don't really want to do that. So exposing clients to that head-on conflict, I think, is a bad idea. But I also, I will often say, listen, we'll sit down on the table, we'll mediate, and we'll have our client present, but in a separate room. And we like it if you do the same. But we don't want to be in the mediation saying things where your clients, getting very angry. I've been spit on. I've had a guy try to fight me in a media, and it's one of these things where you're just like, sir, you're
this is a little beyond,
yeah. Why? This is not this. None of this even makes sense. What are we doing here? And I get frustrated with mediators who don't care about the result. They'll just go in there. They'll go in the room with my client and they'll say, "Hey, you got no case. You should take 10 grand." I'm like, pardon me? But then
I'm here.
They went in the other room. They said, "Oh, you're in a lot of trouble. You're going to pay hundreds of thousands here." And defense counsel and I are in the elevator, kind of being like, "This mediator doesn't care at all. Just somebody cuts a check. That's all that matters to this mediator. The amount doesn't matter. There's no sense of equity or fairness. It's just getting to yes, right?"
Yes.
That frustrates me. And I think there's this huge disparity in mediators. There's so many mediators who don't really know the business. Right? If you're a matrimony mediator and you want to get into employment law, I think that's we could use more mediators in employment law. But you got to practice the field for a while. Don't just come over here with no knowledge of the industry and say, pay this much. Hold on.
Hold on. She raised two excellent points. I think really, really good points there that I think about too. It's like what I hear you saying is about mediation. Some of the benefits have to be a certain conditions in place, right? So one, you want a quality mediator. That's what I was going to say too. It's like that. So someone who's like really been around the block and experienced in the employment law realm. That's a really good point. I often look for that too. Are they seasoned? Have they been employment attorneys before? Which side? Defense, plaintiff, both sides? What's their background? And also, I think you mentioned your client, right? Because yeah, if emotions can run high, and it can be sort of a free for all where people say and do things, and the tempers go up. As you pointed out, a lot of people are not used to keeping a level-headed conflict. Like I've been, shouted at, screamed at, my opposing counsel hung up on the phone at times. I just thought, okay, I guess they're not really, maybe not as polished at this as I am, to be able to discuss in a calm, assertive way, like, you are as well, like I could tell. And so, but our clients don't always know that. So I think like helping to prep the client from an emotional perspective in terms of, and being in a room, I think is a really solid idea. I found that doing Zoom mediations during the pandemic, in some ways, actually, my clients were on Zoom and I'm on Zoom, and they can kind of like feel less threatened, I think, by the person being right there in the room with them, and they have something to ground them. So it can be a mixed blessing, sort of. One hand, you're not fully connected as you are in person, but you're not fully exposed, because rather employers can get very emotional too, especially as you mentioned, those mom and pop businesses that feel this is a waste of my money and time and I did nothing wrong. And then they blow up and say something about, that maybe they shouldn't have said, or maybe they're just so angry that they make a comment that then gets, they threaten interpreted as a retaliation. Like I'll tell clients all the time when I'm investigating a case, like what not to do, right? So if the person is accusing them of discrimination, and they're still working there, and I've had employers ask, what if I fire them? I don't think you want to do that right now, short of some like horrible exit circumstance that the employee punched someone in the nose and this can't happen. But so I think you're right, people aren't used to conflict, and I think mediation can be maybe a good way to resolve conflict, but it has to be something where folks like you and I are on the other sides of the table, helping our clients to cope with the conflict that most people don't like to address.
Yeah, I agree with you there. I agree with everything you're saying. People have to actually want a resolution. That was one of your early points. And then I think the attorneys act as almost like bowling bumpers. When you're bowling and they have the bumpers for the kids, kind of keeps everything in the lane, like you don't want to go off the tracks too much. And with that mediator who has some knowledge, has a depth of knowledge about the field, and can kind of say to the client, sure, but what about this, right? And have you thought about how this is going to look? And I think that's really valuable. I agree with your perspective there. And listen, if there's litigation, it's better for everyone. It always is, right?
Yeah. 100%, Vince. 100%. Yeah.
Eric, it was amazing having you on. I hope we can have you again.